So welcome to the first Debt Collection Advisory Committee meeting of 2026. My name is Herb Thompson. I'm the Acting Deputy Commissioner over the Debt Collection Program. I will be facilitating the transition until a permanent replacement is appointed later this year. It's my pleasure to be here with you today. So today's agenda includes remarks from the Chief Deputy Commissioner, Suzanne Martindale, overview of Bagley-Keene Open Meeting Act and its impact on this committee, presented by Senior Counsel Ann Nguyen. Review of comments received on the scoping regulations, presented by Senior Counsel Emily Gallagher. We will take a short 5-minute break immediately following. Upon returning, we will proceed with a roundtable discussion where each committee member will have 5 minutes to share matters discussed today. And we will then open the meeting for public comment before final remarks. So the committee members online are Humberto Matz, Colleen Miller, Miguel Soto, and is Parisa Esmaile online?
Esmaile, thank you.
Esmaile, thank you. The committee members in the room are David Reed, Katie Neal, and Robert Tavelli. The FPI participants online are Colleen Monahan, Deputy Commissioner of Legal, Ann Nguyen, Senior Counsel for Legal, Emily Gallagher, Senior Counsel for Legal, Unju Chagoya, Financial Institutions Manager, Rosa Gallo, Financial Institutions Manager, and Sophia Touch, Acting Financial Institutions Manager. The participants in the room are Suzanne Martindale, Chief Deputy Commissioner, Adrian Diaz, Deputy Commissioner of External Affairs, Miriam Valdez Singh, Deputy Commissioner of Legislation, and Zam Kadiri, Financial Institutions Examiner. So at our last meeting, we discussed concerns regarding the cost and time burden of the current examination process and introduced a two-pronged approach, which included the full scope examinations as well as limited scope examinations. I want to reiterate, while full scope examinations will continue throughout the year, the majority of our focus this year will be on limited scope examinations. This reduces the financial and time burden on licensees, increases examination frequency for broader coverage of the industry, and improves our examiner expertise through a deeper dive into specific compliance areas. These limited scope examinations will be budgeted for 80 hours. Depending on the severity of the findings or violations, additional hours may be required. I would now like to turn it over to Chief Deputy Commissioner Martindale for the opening remarks.
All right, thank you, Herb. Good morning, everyone. I'll start by thanking this group and our industry partners, of course, for their cooperation, for the vast majority of whom have paid our very first ever assessment, first time doing this, by the January deadline. And 99% of our licensees paid their assessment on time. Thank you for that. I also very much want to thank Herb, Unju, Rosa, and the leadership and diligence of all members of our team to effectively manage this relatively new process, right, and engage with licensees to get everything done. As we shared at the last meeting, over 60% of our licensees paid annual assessments that are under $1,000. So that's pretty low, actually, for many of you. We're also pleased with the outcome in order to respect that businesses, are able to operate in the state affordably while we abide by our statutory mandates under the law. We can also report that the next 30% of our licensees paid under $10,000 in assessments. Any of the higher assessment amounts were really reserved for the very largest national or even global companies that are subject to licensure by our department. I also want to thank DFPI staff for their flexibility. When our team saw some licensees might be miscalculating their net proceeds, again, this was our first time doing this, we thought some folks might actually be overpaying on their assessments as a result. So what we did is we issued an alert back in August, noting common errors that may have been occurring as licensees were calculating their net proceeds. And several members of the industry did take advantage of that effort to right-size their numbers and avoid over, or in some cases underpaying their actual assessment. Our team went further, though. Later, when some licensees only noticed they may have miscalculated after receiving their bills for the assessments in September and October, our team went the extra mile and offered another path forward for those licensees affected to still have an opportunity to right-size their numbers, even though assessment bills had already gone out. to our 1,200 plus licensees. So several members of the industry afforded themselves of this last opportunity that we providing additional documentation to show what the miscalculation was, and then agree to subjecting themselves to a limited scope examination for more complete review by the department. So some actors did receive modified invoices as a result pending these examinations. So again, thank you to the staff around this table for your work, and thank you to the members of the industry for your productive collaboration for our first ever assessment. Before I hand it back to her, I do want to also flag something that we recently posted on our website, and that will be included shortly in our monthly bulletin about a new trend that's a little concerning around service of process that we have noticed is brought to our attention. So in the interest of clarity and communication, we have posted a reminder on our website that under California law, email or other electronic methods are not permitted for serving a summons on persons within the state. And the site is California Code of Civil Procedure 415.10 at SEC. This is all on our website. Again, this will go out in the monthly bulletin and flags the 4 methods of service that are outlined in the law that are legally valid, to make sure that you are attempting to collect on debts legally, because doing so without proper service, of course, would violate the Debt Collection Licensing Act, the California Consumer Financial Protection Law, and the Rosenthal Fair Debt Collection Practices Act. Now, we doubt that anyone around this table or on the Zoom here is engaged in such activity, but we want to help spread the word that such activity is concerning because it could harm their industry reputation, right? We want to make sure lawful service of process is the standard in California. So we are continuing to investigate this issue and investigating complaints, and we'll be examining licensees for potential issues related to these practices. We will hold licensees accountable if indeed they are violating the laws around service of process. So we appreciate your cooperation in that matter. But we value the partnership of this committee and we appreciate your input. And now we look forward to the discussion further on in the meeting, and I will stop talking and hand it back over to her. Thank you.
Suzanne. So in an effort to get through the full agenda today, please hold questions until the roundtable discussion or the open comment period. I will now turn it over to Senior Counsel Ann Nguyen to provide our committee members a cursory presentation on the requirements associated with the Bagley-Keene Act, Open Meeting Act. Take it away, Ann.
Thank you, Herb. Good morning, everyone. Thank you for the opportunity for being here today. My name is Ann Nguyen. I'm an attorney for the department. Today, we will briefly go over the Bagley-Keene Act. Next slide, please. Today's presentation is for informational purposes only. It is based on the most recent guidance as of the date of this presentation, that's today, and is not meant to establish substantive policy or rights and does not constitute legal advice. Next, please. For just a brief overview, today we'll go over California law, bodies covered by the Bagley-Keene Act, what is a meeting, the teleconference exceptions for advisory board, the notice and agenda requirements, regular meetings, public participation, access to records, closed sessions, and remedies for violation. Next, please. The California law, the right to the open meetings, the public's right to open meeting starts with the California Constitution. That's Article 1, Section 3B. 1, it states the people have the right to access to information concerning the conduct of the people's business, and therefore the meetings of public bodies and the writings of public officials and agencies shall be open to public scrutiny. Then we go into the government code, and that's the California Government Code. Bagley-Keene Act is also known as the Bagley-Keene Open Meeting Act, and that is under Government Code Section 11120, all the way through 11132, and there is a link to the ledge info right here, and that applies to state bodies and covers state boards and commissions. Next, please. So the general rule for determining whether a body is covered under the Act involves a 2-part test. First, the Act only covers multi-member bodies, so they have to have more than 2 people. And some examples of that are state boards, commissions, committees, panels, and councils. And second, the body must have been created by statute or required by law to conduct official meetings. If a body is created by statute, it is covered by the Act regardless of whether it is decision-making or advisory. But bodies may also be expressly exempt from the Bagley-Keene Act by statute. Next, please. For the advisory bodies, the Act governs 2 types of advisory bodies, those created by the legislature and and those having 3 or more members that are created by formal action of another body. If an advisory body created by formal action of another body only has 2 members, it is not covered by the act. So for us today, we're talking about the Debt Collection Advisory Committee, and it is an advisory board created by the legislature under Financial Code. Therefore, it is subject to the Bagley-Keene Act. Next, please. So what is a meeting? So under the act, a meeting occurs when a quorum of a body convenes, either serially or altogether in one place, to address issues under the body's jurisdiction. So serial meetings are expressly prohibited by the act. This is use of direct communication, or personal intermediaries, that's like an agent, or technological devices that are employed by a majority of the members of the state body to develop a collective concurrence as to the action taken on an item by the members of the state body outside of a meeting. So typically this occurs when one person A talks to person B, person A also talks to person C, and then it just goes round and round and round, and eventually more than half of the advisory board have all engaged in this separately, but the issue is the same, and that is prohibited by the act. So contacts by the public, communication from the public to discuss an issue is not violated so long as the body does not solicit or orchestrate such act. So you have to wait for the public to contact you. You cannot go out and solicit the public individually. Next, please. Social gatherings are not exempt. You can meet, socialize, so long as you don't talk about the body business, the advisory board's business. And that's the same thing with conferences and retreat. You can have conferences, you can have retreat, so long as the majority of the members are not talking about the issue that would be on the agenda for the next meeting or body business. Teleconference meeting. So this, what I'm going to go over right now is the general rule for teleconference. Right now we are operating under an exception, which I'll go over after this. But the general rule requires that if you hold a teleconference meeting, whether it be through audio or audio and visual, wherever the member is participating from, that site must be accessible to the public, which means that if you are calling from your home or your car, it has to be public. It has to be open to the public, which is generally not advised. This is the general rule. And so all proceedings must be audible, votes must be taken by roll call, and every other provision in the act also applies. So this is the general rule. Now we're going to go over the exception. Next, please. So this is what we're currently operating under today. And this exception is good until January 1st, 2030, when it repeals, and then another set of rules come in place, which we'll talk about at a different meeting. So right now, this exception under the government code authorizes advisory boards to hold meetings, open meetings by teleconference, and that's why we're doing this remotely. And all the members who participate from the remote location shall be listed in the minutes of the meeting. And that's what Herb did earlier when he announced it. So that should be reflected in the minutes. Then another requirement is whoever is participating remotely must be noticed. The notice must be provided to the public at least 24 hours in advance. And what we did here is we listed it at the agenda when we published the agenda so the public knows. The agenda should include information regarding the physical location. That's why we listed the San Francisco office in the agenda, and at least one member, one staff member. So this right now does not require an actual advisory member, but just one member, one staff member to be present at the meeting location. And the agenda is required to be posted at the physical meeting location, but not at the remote location. Next, please. You are also required to list the teleconference number, internet website, and other information describing how the public can access this meeting. And you have to provide this in the notice at least 24 hours in advance, which we did when we posted it at the 10-day notice. And all members must be visible on camera during meeting. This means even if you're calling in from your home, your car, wherever you are, you have to be visible. If you are a member, you have to be visible. Even if you are in the physical location in San Francisco office, you have to be visible. So if somebody steps out to use the restroom, it has to be announced, and either the meeting stops or you wait for a break, but everybody has to be visible. So upon discovering that somebody is not visible, so somebody's remote access cuts off, their line gets cuts off, and it's been a couple of minutes, we hold the meeting, and they can't come back in, we have to end the meeting. And these are the exceptions that we're working with. This provision repeals on January 1st, 2030. When it comes closer to that date, we'll discuss what the next rules are. Next slide, please. So this is the notice and agenda requirements for all meetings. So you have to mail it out, send a notice to distribution list is permitted. The notice needs to state the date, time, and place of the meeting, given the name of the phone number and address of a contact person who can answer questions about the meeting and the agenda. And it contains a brief description of what the agenda items are. Next, please. So the agenda should be drafted in a manner that laypersons can understand it. If it's too convoluted, too confusing, it probably needs to be clarified. When you were putting together agenda, it's not required that you put it as a discussion or action items. So you just put the items on the agenda and you can discuss it. You shouldn't schedule items at particular time unless you want to be bound by them. So just listing the items in the agenda is fine, and your time list for today, example, we listed 10 to 12 and all the items. And a public comment has to be included as part of the agenda. This allows an opportunity for the public to participate. Next, please. Regular meetings. So regular meetings are what most bodies do, or advisory bodies. There's generally a rule on how many meetings you set a year. It could be a couple of meetings a year, but these are your regular meetings. Occurred under normal and ordinary circumstances, and this requires the 10-day notice, along with the agenda and things we covered earlier, posted on the internet, a website address must be included, and it also has to be ADA compliance. The agenda itself has to be ADA compliant, and the physical location also has to be ADA compliant. Next, please. And the public participation, this is where you have your public comment section, and you hold your meeting at a public space or a space where the public can attend. They are not required to sign in their name or give their phone number or give any information about themselves to participate in the meeting. That is separate from security measures that are required if you are in a building behind a door that requires either a swipe or an ID to get in. So that is two separate process. So if they have to have an ID to get into the building, that's okay, but you cannot ask for an ID to speak, or their name or their email address or anything. And next, please. And next slide, please. This is access to records. So access to records, the public is entitled to all documents that you use at your meetings, and the documents have to be ADA compliant. So for example, this slide today has to be available to the public as soon as possible. Next, please. And the location of the meeting has to be accessible, that you can't be discriminated, and it also there's no discrimination on the location of the meeting. Next, please. So remedies for violation, this is a personal. So if you violated the Bagley-Keene Act, it is a personal responsibility. It is not the department's responsibility for you. So the remedies for violations could be misdemeanor criminal penalties or civil penalties. They could file a complaint with the AG's office, with the district attorney's office, or they can write a letter. The public can write a letter that expressing their concerns about the members violating the Bagley-Keene Act. Yeah. Next, please. I think that is all for my slide today. Thank you very much.
Thank you, Ann.
Back to
I
you.
will now turn it over to Emily Gallagher, Senior Counsel, to review the comments received by the department on our scope regulations.
Thank you, Herb. So I'm Emily Gallagher, Senior Counsel in the Legal Division. I was looking forward to meeting you all in person, but I have a cold, so I thought best not to risk it, so I'm virtual. So thank you to all of you who submitted written comments to the latest draft of the scope regulations. I hope you've had a chance to review the draft, maybe even review the comments, which I know Herb sent a link around to. And before we run through the draft for discussion, which we've done in the past, I'd like to just start by level setting with everyone on process. So all of the drafts up till this draft and including this draft have been part of the informal phase of the rulemaking. So we intend this to be the final draft of the informal phase. The next step will be to formally propose the regulations, and this will include a notice published in the California Notice Register. When we do propose the official draft through notice, it will include a statement of reasons where we'll explain why we chose what language we settled on. And once that's been noticed, there will be yet another opportunity for written public comment. So it'll be different than what we're doing here. It'll be written comment only, and we are required by law to respond to those written comments in writing. So if we make any changes based on those comments, we will have yet another opportunity for comment. So that's just a little quick description of where we are in the process, and our discussion today on this draft will inform what the formal draft will look like. So I'd like to do what we've done previously with this committee and bring up the language on the screen so that we can discuss. Let's see. So despite Herb saying that to hold comments till the end, that is still true for the public. However, for this section, I would like the advisory committee members to feel free to come off mute, to speak up. You can do that yourselves. You're welcome to raise your hand. Just a note that I might have trouble seeing hand raises, so everyone is welcome to just jump in and tell me that someone needs to speak if I'm neglecting somebody. Based on the comments, I think we should begin by focusing on the creditor, servicer, and attorney exemptions. And if the committee members have other sections they would like to discuss and we have time, we can discuss those. And additionally, if any of you want to use your roundtable time later to discuss the regs, I'm happy to come back for that. So we have until 11:10. So let's begin with the creditor exemption. Yeah, page 4. Perfect, right there, subdivision D. So the double strike through is what was previously in this section, and it goes on. We're not going to skim down. We're just going to leave the double underline, which is what the new language says. So just a quick read. Our current exemption says a person collecting debt arising from a consumer credit transaction that meets the following requirements is not required to be licensed under the DCLA. The person extended credit underlying the debt to finance goods or services it provided, and in the ordinary course of business, that person uses a licensed debt collector to collect such debt when the debt becomes 90 or more days past due or is charged off as defined by another provision of law. So please, if you are a member of the advisory committee, please speak up if you've got comments on this section.
And if we could just pause, can you read the screen?
Yeah,
Can you read the text? Is it Okay. Squinting at first, but yes.
Okay, good.
And get focused.
There
Okay.
you go.
Yeah.
Yeah, it's bigger now.
If I'm understanding the way it's written now, it sounds like passive debt buyers. So those are debt buyers that purchase the debt but don't collect it themselves, but instead they use a licensed collection agency. They are exempt from licensing requirement.
The buyer.
A buyer, so this would be, I'll draw your attention to D1. The person extended credit underlying the debt to finance goods or services it provided. So if you're talking about a debt buyer, it sounds like that person would not have extended the credit underlying the debt for goods or services it provided.
Okay, so those, I understand. So those are and, not an or. Okay.
Right, yes.
What about those who extend credit in general, not for goods or services, but a loan maker? This would exclude them, correct?
So this would only exclude them if they extended it for goods or services that it provided. So I think that would not, unless someone else is reading it differently, I think this language would not include such lenders. They may be exempted by the statutory language of the DCLA, as many creditors are exempted there, but it would depend on the situation.
So a lender loaning money is the provider of a service technically. So for clarification, they're still governed obviously under other finance structures. So would they be a part of? In other words, they're not buying the debt, they're actually loaning the money. They're the original creditor. They would still be governed, for clarification.
Yeah,
That's a
defer to
good-
Emily.
Yeah, so that's exactly why we're having this discussion. I appreciate you raising that, and I'm not going to say for sure how this would be interpreted because it's just a draft, and that kind of comment is exactly what we need for clarity. So I guess my question back to you and to the whole committee would be, is that an exemption we would want this to include, or do we want this only to include
Are
entities
they,
who are in a different type of service, or is lending a service that we would
Yeah.
want
Are-
to exempt?
I guess my question would be, are they already heavily governed under the DFPI, under the lending part of it? So would that carry over to the collecting of the debt? As long as it's not charged off, they're servicing the debt. They're not under that, they're already governed, right?
So like if they are otherwise licensed by us?
Yeah, in another division, or for example, a hard money lender loans money on a commercial debt, that's commercial. So if they loan money on a primary resident or something of that nature, is what I'm really referring to. Or any other lender, I guess.
Again, we have different laws that cover different product types, so
Right.
whether it's mortgages, CFL,
Right.
things like that, and then for either of those, there's already an exemption built within the
Okay,
DCLA.
that's.
There are there's some statutory exemptions already that
Right,
may separately
that's-
apply.
Yeah.
This is trying to get at one clarifying piece,
Right.
it's one of a few exemptions that are in the draft regulatory text, so,
Yeah.
Okay.
Yeah,
that
I have
clarifies.
actually two comments as well about this, just for consideration as we go into the next draft. So if this is an and statement, it sounds to me like the creditor who is lending and using a debt collection agency to collect for debts that are 90 days or more past due, that's covered. It doesn't necessarily talk about creditors who are collecting themselves, for example, before that 90-day past due phase. So it's kind of ambiguous whether they would fall under that. So maybe providing some clarity about that. And then the other comment, just for consideration, again, there are a lot of fintech companies now who are, for all intents and purposes, as the consumer knows, they are doing business with XYZ fintech company, but there's an underlying bank that's extending the credit. So it's, I forget what the exact terminology is, but there's this group of fintech companies that are extending
bank
credit,
partnerships.
but they have,
Yeah.
So it's figuring out where they fit within the scheme and clarifying within the scheme where those kinds of companies would fit might be helpful.
Okay, thank you. And I want to just make sure that we're on the same page. So this would exempt a person collecting the debt arising from a consumer credit transaction that they extended, and that is not collecting after 90 days. So if it's within those first 90 days that they're doing their own collection work, then they would be exempt.
Or charge off.
Yeah, or
Yeah.
charge off.
I think
Yeah,
if that's the intent,
Mhm.
number one needs to be amended because I still get hung up on the to finance goods or services because there are actual lending companies that all they do is finance goods or services that they provide. And so I think it causes confusion. It makes it much more narrow than that intent.
So that finance goods or services that they provide. So are you saying a service other than lending? They provide
Right,
something else?
right.
And they
Like
service. Okay.
there are companies that will finance you for actual services that they provide.
Okay.
So I think that that narrows it more than what your stated intent was.
So you're saying those people or those companies, as you read the language, would or would not be exempt?
They would be the only ones exempt.
Mm-hmm. Yeah.
Like that specific niche, as I read it, would be the only ones exempt. But I think you're trying to say, companies that provide financing for goods and services. So maybe take out the it provides.
So I'll take that as a comment to extend that. If that's correct.
Yeah.
I just want to, as we've been doing this for several years, one other piece of background I want to give everyone is we did receive comments when the DCLA first passed from a huge swath of a whole variety of businesses, including many businesses that don't think of themselves as financier, as providing finances, companies that do things like they provide services and they just ask for payment after the fact instead of beforehand, or they let you pay on a payment plan. And so those are companies that when this was initially drafted, we were definitely had in mind. It has evolved, so I'm not going to say that that's necessarily the only purpose of this section, but just a bit of background. So if we want this extended to cover more businesses than just those, I'm happy to take that as a comment, but I just want to be clear that that's not necessarily our purpose. And we
Got
weren't
it.
necessarily thinking of finance or companies financing other things. Just generally providing financing.
Tell me that.
Emily, we got a question in the room.
Another clarification issue, for example, in the debt collection third-party process, your client has an account, they turn it over to you and it's 6 months old. So that, I'm just clarifying that 90 to 6 months, it's not been charged off on their books. That's different. I mean, banks are regulated, they have to charge off at 90 days. Is there a clarification between that? For example,
Well,
most-
it's 90 days or more past due or charged off, so it could be one or the other.
So but they consider the debt past due and that's why they turn it over, but they should be turning it over, let's say at 90 days. They don't. Are they governed under this kind of a structure?
Yeah, so if they're collecting on their own debts,
After 90 days or charge
after
off?
90 days, then they would be considered a debt collector here
Okay,
if
great
they-
selling point for me.
Yeah, I mean,
But-
this
But I
would,
mean, and I get less complaints if somebody turns it over, I can help my client faster, but the point I'm really making here is you're gonna have a lot of creditors out there that don't turn their debt over within that first 90 or after, right at 90 days. They would be governed by this under the way this is currently written. as I
if they
understand it.
financed it for goods or services that
Well,
they provided, if we're not.
Yeah, so an
and
open
that
account.
Comes back to your original question about whether
So-
financing counts as a service.
So an open book account or a contract that breaches, they don't follow the terms of their agreements, say it's net 30, so now it'd be 120 days, that would be past the 90 days past due.
Emily, we got another
Go
comment.
ahead.
yeah, I guess I'm a little confused. The law exempts lenders, not lenders before 90 days, but lenders are exempt. And so hypothetically, let's say ABC Bank has an account that becomes default and they charge off. but they collect on those accounts and they never use a third-party collection agency and they never sell those accounts to a debt buyer, are you saying that that bank would have to become a licensed debt collector if they continue to collect on that debt in-house?
No, if the text of the DCLA exempts them in the exemption section, they are not,
Banks are already,
they are exempt.
90-day charge-off rule, right?
Well,
We can't bring
but
someone
but
in.
plenty of lenders continue to collect and never use a third-party collection agency. So
Fine. If they're exempt, they're exempt. If they're exempt from the language of the DCLA, then this is not relevant to them.
but this is confusing because if you read this would suggest that it is applicable to them.
So
there's a statutory exemption for depository institutions in the statute, so
So they
you don't even need to worry about these rights if you're a bank.
Okay.
Well, what
Yeah.
about the lawn
That's
service?
right.
What about the lawn service company? Not a bank,
Mhm.
lawn service company, does lawn servicing and they have default accounts. They don't work with a collection agency, they just collect in-house. So we're not talking about a financial institution. Would they become a debt collector?
It's a department within the bank, you're saying?
No, it's not a
that's
bank.
sorry,
It's an
that's
app.
precise. That's a great example of a person collecting debt arising from a transaction.
Yeah.
Where they extended a credit underlying the debt to finance a good or service that it provided. So if you were to just read the DCLA and recognize that it comes from Rosenthal and Rosenthal has applicability to these types of creditors, potentially, yes, they would need a license. But under this exemption, they would not need a license as long as they engage a licensed debt collector after 90 days or after it's been charged off. So there is a point
they
at
were
which
saying we
they
have to
would
use
need
one
to
month,
get a
yeah.
license from us if they're engaging in the business of debt collection at that point.
So any non-financial institution, a plumber, electrician, a lawn service, if they want to collect beyond the 90-day period, they would either have to contract with a licensed debt collector or they would have to become a licensed debt collector.
Yes, that's under this exemption. That's correct.
Wow.
That's
I don't think any state in the nation has done that.
Yeah, that may need,
That's a little crazy.
we can,
So yeah, we are. Are you looking at this as that period needs to be longer, or they should get an
No, I
exemption
mean-
no matter how
Yeah,
much?
I'm
they
saying that
The original credit.
whoever extended the credit, if it remains with them, that they should have an exemption. So the plumber, the electrician,
Yeah.
the lawn care company, the daycare center, the whatever non-financial institution, if they, the dentist's office, if they were the one who extended the credit and they continue to attempt collection in-house, it doesn't matter. It could be 3 years later. Not, they would not need to be licensed.
Right.
The only time that, if they were to sell those accounts to a debt buyer or contract with a third-party collection agency, yes, absolutely, the debt buyer and the third-party collection agency needs to be licensed. But the originator of the loan, if it remains in-house, there was never an intent in the statute that those entities would have to become licensed.
Okay, so I'll definitely mark. I'm clearly marking this as a comment. I do want to point out though that the DCLA borrows or copies the definitions used in Rosenthal, and Rosenthal has been applied to original creditors, which I'm describing those lawn service companies. I'm using the term original creditor. So that's where the idea that they would need a license comes from.
Yeah, that was never
if we don't want them-
legislative intent.
Yeah, so if we don't want them, we would need to be clear about that And you're saying they should get a blanket exemption regardless of how long they collect, no matter what type of fees they might
Correct.
charge for that collection, no matter how much that impacts their business.
That could create a huge problem.
Emily, I know this is gonna run long, but Katie has one additional comment, then we can move on to the next section.
Thanks, I appreciate it.
Just very briefly to a little bit bolster what David was saying, under the FDCP, and I know this is a different law and states are allowed to be more prohibitive, but the thought behind not including creditors in the definition of debt collector is because they get reputational damage if they engage in certain practices when they're trying to collect their own debt, because then that activity is tied to their own name, and that sort of curbs their
Ability to market everything.
well, it encourages compliance and good practices for them, because then they're not getting that reputational hit back, which then might cause fewer return customers. And as David was saying, to apply this broadly, DFPI is going to have a really hard time educating the public that, hey, teenager who's running his own lawn service
Yeah.
business, you are potentially a debt collector and you have to go through this whole licensing scheme. That could be a very big
What,
educational
Yeah.
endeavor for DFPI.
you think of the number of businesses in California that do any kind of accounts receivable, you're gonna be bombarded as DFPI. They're gonna be bombarded by attorneys. It's gonna create a problem that didn't exist before. I mean, as much as I would recommend that any client turn over their account readily, but the average age is probably 6 months or above for a contingency agency. So that means those clients are holding on to those accounts for well beyond 90 days because they want to maintain a relationship too. And they want to do workouts with these people on a one-on-one basis versus a lending institution approach. So that's
Okay.
probably.
Understood, appreciate it.
I want to let Humberto speak. I see he's got a.
Yeah, I just want to echo the perception of this is just going to be that this is a small business owner's trap. They're going to either be trapped by litigation from attorneys that are representing the consumers, or they're going to be trapped by regulatory regulation. This is just a really bad idea.
It's unintended.
All right, thank you. I think we could keep talking about this, but maybe we
Back
should move
to
into
it.
servicers, because I think there's also going to be comments on the servicer exemption, so we can come back to the original creditors later if you'd like. Does that sound okay to the committee?
Yes.
Okay, then we're going to pop down to the next page. Thank you, Zan. Okay, so subdivision E. This section also has gone through some changes, and we had a lot of written comments, so I'm sure this is going to also be full of comments. So right now, this exemption would be for a person solely servicing debts that are less than 90 days past due and had not been charged off, is not required to be licensed under the DCLA. However, for purposes of this subdivision, we have an exception to that. A debt is we define 90 days past due, and then we say a person is not exempt under this subdivision if the person engages in any of the following practices during the first 90 days, where these practices would be reporting negative payment performance to a credit reporting agency, seize or impair use of collateral, or contact a debtor's friends, family, employer because of their relationship with the debtor. So if in the first 90 days, someone collecting is doing any of those things and they are not the original creditor, they would need to get a license. So let's hear your thoughts.
So servicing debts that are less than 90 days on behalf of the original creditor? That's- No.
No, just
No.
these
Okay,
two.
good.
No.
Thank you.
Could you remind me what the definition of servicing is? Servicing debts?
We have not defined servicing within
Okay.
this regulation. I'm happy to write that down as a comment that you'd like us to. If
It might be helpful since
Okay.
it's used as a term of art here.
I know it's like reading a puzzle, so if you have
Yeah,
questions for clarity.
Persons.
So I think for me, what sticks out is 2A, reports negative payment performance to a credit reporting agency, if you report to credit, you have to do that every 30 days.
Oh.
So are we saying that if an account is 30 days past due, you lose this exemption? I mean, that is an incredibly tight deadline.
Well, this doesn't, we're talking about the first 90 days after the debt is past due. So the first 90 days after 90 days past due.
Okay.
Not like you're a day late or something like that. That's not,
Technically, you'd be 120, if your terms are 30 days.
yeah, so if it's saying 30 days after it's past due, that's about to be 120 days
Right.
that you, since you made your last payment
But
or.
credit
or
reporting
required
would be
payment.
governed under the FCRA.
Okay, because the way I read it is so it's and this may be overly technical,
No, I
but
appreciate it, please. Yeah.
so you at 90 days for a reporter, you have already been reported negatively at least twice.
I see. I see. Okay, I see the concern.
Yeah.
Okay. Thank you for that.
I think the word solely as well, does that mean like it's hard for me to read this with that context. That means your business has to essentially only be doing these things to be exempt. Am I reading that correctly?
Yeah, so if it's a debt collector who is otherwise subject to the DCLA and this is just one part of their business, then they would already need to be licensed for that other part. So yes, this is very limited. It's just for companies that
Okay.
are only doing this sort of sending payment reminders in the first 90 days, let's say. Does anybody have we can talk about anything, but does anybody have proposed ideas about how servicing could be defined or how you use servicing in your business or in your industry?
I think it depends on what the intent of this is supposed to be. So, for example, in the traditional debt collection space, like TrueAccord, for example, we say that we're servicing the debts and that we're collecting on the debts, right? We are communicating with consumers, we are taking payments. I think in the student loan context, servicing means something very different. I think that is typically managing the debt before it's gone off to collections for the most
Right.
part. So I think maybe honing that into the specific practice, whether it's the collecting debts versus servicing, which is more of the management of a debt that has not yet been charged off.
I think another clarification, and it goes back to the 90 days. I don't think that an original creditor has ever been governed under a 90-day rule charge off. And so anything you do along those lines, if you can get rid of that part of it, because a creditor, the original creditor should have the opportunity to charge off that debt based on tax purposes or whatever they're going to do, not regulated like a bank. And I think that's maybe a misconception that, first of all, I don't know a creditor that they always ask me, should I charge off my debt when I turn it over? Should I charge off my debt when I do my taxes? I said, talk to your accountant, because it's really a personal business. It depends on their entity. If it's a C Corp, S Corp, LLC, they could have different cash reporting requirements for IRS, whatever. But it's never been in my understanding in the 45 years that 90 days is a mandatory charge off time. And I think you've got to get rid of that much, which might solve several problems. Is that right? Does that make sense to you?
Emily, specifically regarding this term servicing, you might look at those laws regarding student loan servicing to see what kind of definition they use, because I think that is what you're trying to get here. So that's probably the correct word, but just further definition so that when people are reading this, they're very clear what this means, I think would be helpful. But I think you could get ideas for how the federal laws define it.
Well, and we have the Student Loan Servicing Act in California as well.
Oh, perfect. Yeah.
Which has a definition of servicing. Yeah.
Right.
Okay.
So would this apply to performing loans or just non-performing loans?
So I'm sorry, so you're saying if a loan is not, is less than 90 days past due, would you need a license to collect on it? Because the purpose of this section would be to, if someone is handling accounts that are less than 90 days past due, they would be exempt. Subject to
Sure.
subdivision 2.
Well, no, meaning, so if it's a performing loan and they're using a servicer, I guess one can make an argument it's less than 9 days past due because it's
Mhm.
performing. And they may be, doing some of the activities that are addressed there. There may be a reason to reach out to the a family person or I mean, in certain circumstances, depending on what the terms of the contract are for, if they can't get in contact with the lender. So I just want to make sure that this section does not apply to performing loans.
Yeah, I'm hearing a lot of concern about the exceptions to the exemption in subdivision 2, which sound like I'm hearing both from you and from Callie that these are things that are maybe not routinely, but are often done by collectors or company or servicers before the loan is 90 days past due, and you're concerned that this will swallow the rule or swallow the exemption?
Yes.
Okay.
Like skip tracing typically happens after 30 days of no contact. So the skip tracing at 90 days, if it's going to occur, it is likely already occurred also.
There was also some terminology that RMEI put in their letter that was a little confusing. There are some undefined terms here, and I think you're intending it to be related to a similar term, but I mean, you mentioned debtors. Debtors is not a defined term. It appears to mean but is it meant to be different than consumers? This essentially, and I guess I'm asking, is consumers and debtors, are they the same thing or are they different? Because one is defined, the other is not. And the same thing related to a debtor account. How does that differ from a consumer debt? Because we define consumer debt, we don't define debtor account. And then also, what is an account? Is it different than consumer debt? I suspect the intent was to apply to one terminology, but basically using synonyms is what I suspect. But I think we need to be very careful in describing what we mean. And an example is right up front, which is a person solely servicing debts. Debts is not defined. I think there you may want to say, consumer debts. A person solely servicing consumer debts, since consumer debts is a defined term. But anyway, I just wanted to highlight that as well.
Also note that
Yeah.
these terms are defined in statute as well.
Yeah.
Right.
A debtor and consumer are the same under the law.
Okay, so we have 15 more minutes before this section concludes. So I'd like to just pop down to the attorney exemption, as that was the other one where we had the most comments, and I want to make sure that committee members have an opportunity to discuss it if you'd like. So let's head there. So this section has also gone through significant simplification. We got a lot of comments on that. So currently our exemption would read, an attorney collecting a debt on behalf of and in the name of a client solely through activities that may only be performed by a licensed attorney is not subject to licensure under the DCLA. So please, anyone who has a comment on the committee, please speak up.
I think that clearly defines the issue. That's what we were looking for at the onset originally.
I do
I
have,
guess,
sorry,
oh, go ahead.
I actually do have, regarding the definitions, two questions with regards to the scope. The words solely and only specifically. I'm sure practitioners amongst you already know, like what an attorney can do, like the list of exclusive things that an attorney can do is more narrow than I think some folks might expect. So things like appearing in court, drafting and signing pleadings, obviously on behalf of a corporation, for example, that's an attorney. But what about sending the collections letters or informal negotiations over the phone with a debtor, things like that, which are also things that attorneys do? Would that engaging in those letter activities mean that they fall under this fall out of this exemption, or would they still be included?
If I may, we went through this with some legislation a few years back, and it came down to the letter is still an act from the attorney. The communication from an attorney is all acceptable. It's when they staff an office with collectors, then they're really a collection agency that's owned by an attorney. That needs a license. Whereas on the other side of the coin, if they're just practicing law, and that's part of practicing law, is you're still required under the law to notify somebody that you've been assigned or been referred to that attorney firm. That was acceptable under their duties and activities. That was heavily discussed, not only in the DCA or the DFPI at one point, but it was also over the years with the legislation dealing with that. That helps.
Gotcha. Appreciate the history. I won't pretend I knew that, so I'm grateful.
On the attorney exemption, did staff talk at all or discuss the potential for added clarity that RMAI had suggested? It's the language, basically the first sentence remains the same except for clarifying a law firm or an attorney. Because obviously those are two different entities, and a law firm would be the licensed entity unless it's a sole practitioner, in which case, all right, then an attorney would be licensed. But certainly I don't think we want to insinuate that attorneys themselves individually are being licensed, because this is not intended to be a license for individuals. It's a license for business entities. But RMAI had suggested the following language for additional clarity after the sentence. This includes engaging in activities that are reasonably necessary or required to be performed prior to the filing of a legal action, including the offering of a settlement or providing a required consumer notice. A law firm or an attorney collecting a debt on behalf of and in the name of a client and who does not engage in legal actions on behalf of their clients is required to be licensed under the Debt Collection Licensing Act. And I think that's kind of what the intent of the department was, that there are attorneys or law firms out there that collect on behalf of an entity with never intending to bring suit, just filing, basically performing collection activities. But and I think that's what you're trying to prevent, a loophole, essentially. But there are law firms that have a process that they go through for the filing of suit, and including complying with certain legal requirements of providing consumer notices, engaging in settlement negotiations, things of that nature. I think that would be within the spirit of what you're indicating here, that is a licensed attorney. It's a law firm performing legal activities.
So I'll just respond to your first comment about the definition for attorney or law firm. We did in the regulations, I'm not going to have you jump to it, Zan, because I feel, we can if we want, but for now, let's not. Where we define how we're using attorney, and we do define it to include law firms.
Okay.
just so that it's easy to put the same
Yeah.
word throughout, but we can consider changing that if it's
Yeah.
gonna
Yeah.
cause confusion. Yeah,
There was a case back in like 91, it went on from like 90 to 92 or something like that. It was a case, and after that, there was a law written, I want to say somewhere between 92 and 94, about the distinction between an attorney and a law firm. And it generally, because law firms had practices of there's a collection law firm, and they had people working there, but also multiple attorneys doing collection work, or associates being brought in to do collection work would qualify. And they literally wrote an exemption for lawyers as opposed to law firms. And you might want to go look at that particular law.
yeah, we did review that. I
Okay.
recall that that Rosenthal at one point drew a distinction
Right.
regarding which ones they were
Yeah,
who was subject and who wasn't, but now law firms and attorneys are both subject.
right.
So it's
Right.
not as yeah. So, okay, any other comments on this section? Okay, we have 7 more minutes. Does anybody want to go back to either the creditors, the servicers, or is there another section of the statute, or I'm sorry, of the regulation draft that you wanted to discuss?
Emily, I have just a broad question. So, and this doesn't have to do with just the statute, but in general, sort of these timeframes that are written into these rules and the laws and everything. I noticed with True Accord, in terms of disclosure requirements, there's something that's required. I think it might be after 90 days, but before charge off. And then there's a disclosure for out of stat, but then there's no disclosure for that like middle period. So I don't know. It might be helpful if you haven't, you've probably already done this, but if you haven't, to map out almost like a time frame of the life cycle of a debt to make sure like all the different portions are either accounted for or explicitly not accounted for, just so it's clear and there aren't those gaps of like, well, there's something to do with these pre-90 but no charge off, but then this like charge off the out of stat period is, I'm not gonna say it's like, the Wild West, but essentially there's nothing there. Because that was always very interesting to me regarding specifically the disclosure requirements, that there seems to be this early stage disclosure requirement, late stage disclosure requirement. There's obviously the traditional Rosenthal Act disclosure that has to go on all communications, but it's just to make sure that there aren't gaps and that there's clear for the life cycle of a debt of where these rules apply.
Okay, yeah, I appreciate that.
And I just have a general question. Has the department ever done a survey of its licensees to determine when the average charge off is? I know that we consistently use 90 days, but that's not necessarily when people are charging off, or even when the account is going delinquent based on their charge off. Have you guys ever like considered conducting a survey just to ensure that the trigger is 90 days and not say 120?
I think I'll chime in. I think it's gonna really depend on product type.
Right.
For what that type of information. So if we were to do all of our licensees, we're gonna get back a blended number that's not gonna be reflective of the actual product.
It really goes back to what I said earlier about clients charge off their accounts at different times. Some of them do it at the end of the year when they do their taxes, but they assign them, and it's an accounting principle, not when they assign them to a collection agency, for example, they're not necessarily even charged off. They're literally assigning the account for collection, and then there's a determination somewhere in the year that the creditor makes to charge off the debt based on feasibility of collections.
Right. And I guess my major concern is that this is triggering a lot of obligation to hand this over to a debt collector when the time may not have occurred to do that.
When it's not.
Yeah, when it may be
time.
premature for some industries. Like it may be wholly premature to hand an account over like 60 days before charge off.
You actually solve the problem by not using the first party creditor mandate that there's a charge off date. I mean, that really, I'm sorry, you're telling, it's just like we talked about earlier when we talked about there's thousands of creditors in California that will have no idea that this is happening. They'll have no idea that they're governed to be licensed or have a 90-day requirement to charge off. I mean, if you stay away from that, you stay away from the whole problem, it seems to me.
Or
Well, it's not
potentially
a
even
90-day trigger to charge off. We're not saying it has to be charged off at 90 days to not require a license. It would just be use a licensed debt collector at 90 days.
Yeah, that's the same thing though.
Yeah,
Well-
it's, the term charge off generally comes through the Federal Banking Act. It's a requirement for banking institutions. When you get outside of lenders that are in the area of financial services, charge off is not a common terminology. I would argue that most lenders outside of the banking community never charge off.
So charge
you-
off here is defined from the definition of charge off in this regulation is borrowed from the Fair Debt Buying Practices Act.
Correct.
Yeah.
Right, but that again was focusing on when a bank charges something off. But again, you know, if you're trying to pull in daycares and dentists and lawn services and pool boys and everything else into this act, no one will know what charge off means because they don't
Right.
do it.
And that actual language you just used, the debt buyer, is they're buying charged off debt. That's different.
Right.
Yeah.
Right. I mean, yeah, exactly.
It's creating a problem that doesn't need to happen, really. I think by staying away from that, you're solving a problem, well, that we don't even have yet. You're trying to solve a problem that doesn't exist. Because an original creditor, other than a financial institution, does typical charge off, or a creditor who sells their debt to a debt buyer is already covered under the Debt Buyer Act. Is that clear?
Yeah.
Okay.
I recognize we're at time, so we could
Yeah.
continue this discussion during the roundtable if the committee members would like, but at this point, we'll take a 5-minute break and reconvene at 11:15. Then you mute the mic.
Hi, this is Rosa.
Welcome back, everybody. Can you hear us?
Yes.
Perfect. Right, so time for the roundtable discussion. I would like to turn it over to the members of this committee. Please feel free to raise your hand if you're online. I'll start with providing the opening discussion to members attending virtually, and then move to those in the room. Umberto, you're up first.
So I have a question about earlier, the limited scope examinations and that you're dedicating 80 hours to each examination.
Yes.
How do you come up with that 80-hour number?
So I think to start with the limited scope, let me talk about the full scope. So our full scope examinations are a full review of the compliance management system, which is comprehensive of board management oversight, as well as the compliance program. So we're doing a modified version of a full scope where we're just going to focus on a very specific part. So it might be one part of the compliance program. So, I'll tell you the focus this year is going to shift really to communications with consumers. So whether that's letters, call recordings, text messages, emails, Reg F sort of compliance standards. But that 80 hours depends on the size of how many accounts we scope and how many calls we have to listen to. That 80 hours is very, in my opinion, reasonable, the work that goes into that part.
So is this going to be done virtually to cut down on agency expenses?
Certainly. So all of our limited scope examinations will be done off-site, again, with the caveat that we need cooperation from our licensees in order to facilitate this process.
Okay. And is there a set hourly rate?
Yeah, so our hourly rate hasn't changed since, I'd say, the beginning of last year, even previous year, but it's $120 per hour.
That is a department-wide rate now.
Every examiner is 120. But again, depending on how the process, it's 80 hours budgeted, could be less, could be more. Obviously, if there's significant levels of findings and violations, it's going to probably be on the higher side of that.
And then size of agency as well.
So size of agency comes into consideration now when we do look for full scope exams. Size of agency is definitely a consideration.
Okay, thank you.
Okay, that's great.
Okay. Callie?
I was just wondering, where is the division in its examination process? What percentage of licensees have been examined? Are you on pace to meet your goals for this year?
Great question. And I'm going to rephrase it. So the division is inclusive of other programs. I'll say for the debt collection program, I think we did 20 exams last year. Some of them are still in the process of being finished up. This year, we're certainly looking to ramp that up. The numbers are going to be a lot higher, but the majority of those exams, like I said, are going to be limited in nature. So we'll probably end this year around 100 exams. I'll call that conservatively.
What percentage of licensees is that?
If you 120, I'll call it in totality, 120 exams would put us around that 10% threshold.
All right, thank you. And I just want to go back to the 90 days real quick. I think it would really benefit everyone on both sides to know the makeup of the licensees. If we knew what their charge-off dates were, what their delinquent dates were, if they even charge off period, it would help us to make sure that when we are reviewing these regs, we are giving some accuracy to the timing. That's it. Thank you so much.
Thank you. And Carissa?
Thanks. I just want to echo what other people were saying about the original creditors and really using the example of the plumber and the electrician, and the others. And I'm wondering if they're not exempt, if there's a threshold that could be defined for really those solo entrepreneurs or the smaller group to do that. Or that there's more education, because I can guarantee that folks have no idea that if there's something like referring to the Rosenthal piece, that there's pieces on the record that exist. I can sense that people have no idea that they're not doing that. They are accidentally doing something they're not supposed to be doing in those ways.
Thanks. I'll just say, Callie and Persa, I did note your comments with regard to the regs.
Miguel, Humberto, you have your hand up.
Yeah, going back to the completed examinations, do you have the average cost of what those examinations, what the licensees paid?
I don't have that information. I would say most of our examination information is confidential. But yeah, I would say ballpark of exams that were being conducted last year ranged anywhere from 15,000 to 25,000. So we're looking at, I'll say, some savings to industry this year. Again, really the whole preference for us from the program's perspective is to get more examiners in the field reviewing more licensees, even if we have to narrow our scope of exam.
And then do you have an idea, or can you give us an idea of what the average agency size was that you examined?
Based off what metric?
Well, we can go as far as revenue, we can go as far as employee count. I'm just looking to see what agencies should be expecting.
Yeah, I wouldn't be able to tell you average. I can tell you we've obviously touched all aspects of agencies with revenues in excess of $1 million, asset size of 10 million or greater. We've done, I'll say, more of your mid-sized businesses in that $1 million range. We've avoided, for the most part, with the exception of maybe 1 or 2 exams, true what I'd call small operations, where let's say the FTE count is 2 to 3 individuals. But yeah, it's hard for us to use FTE when we have companies that hire other agencies to engage in services that they provide. That information is not necessarily reflected in a true FTE count.
Thank you.
There's no questions for the committee members online, or no additional questions at this time. I'll turn it over to those in the room.
I'm happy to. Oh. So I'll just make 2 comments. One is this whole rulemaking process is hard. You guys have a heck of a task ahead of you. I remember going through this process with the CFPB when they were making Reg F. It's really, really hard to account for all the situations and make sure the end product is something usable for you as regulators, for us as businesses to be able to comply with. So I just want to acknowledge that, like, there's a lot of back and forth that happens. There's a lot of probably feeling like we're just trying to push a boulder uphill. But I really appreciate all the effort that's going through to try to reach an end product that is workable for everybody involved. And the second comment I wanted to make actually goes back to something Martindale mentioned in the very beginning of the meeting, which is the service process. That really caught my ear, primarily because making sure that debt collectors and law firms that work on behalf of debt collectors are properly using the proper channels for service of process has another benefit. There's obviously it's the form process what's required, otherwise the lawsuit is not really valid. But on the other hand as well, there are so many scams, so many phishing emails these days, so many different ways that consumers can get caught up in messes that really, really harm them, that making sure that agencies and law firms that are filing follow these proper processes and avoid the email when it's not allowed, and the consumers know what processes are allowed or aren't, really helps prevent consumers from getting in real big trouble by the scammer. So I appreciate that as well.
Do you want to go?
It's up to you.
Well, I'll just make a couple of comments. One is, I want to go back to this Rosenthal Act where it says charge off. Is there a legal requirement for a creditor? I think this answers a couple of ways of going about it. Is there a legal requirement that a creditor has on consumer debt, other than finance? Is there a legal requirement to actually charge off the debt? And I don't think there is. And so that may help solve the other subject matter. The other thing that, I know that. So when you get into, we were talking earlier about smaller agencies. I mean, I have a tiny agency now after restarting, that does debt collection third party. So we do very little on consumer, and most of what we do is commercial. But there is a little bit there. So when they report, I guess, both or whatever. And then you guys, how do you determine what gets examined, or how do you determine who gets examined, I guess? How do you set the criteria?
So very good.
Complaints are one thing, but.
Yeah, I mean, we've had the conversation previously with respect to like duplicative complaints and CFPB, or even on our internal database, we go through and clear out. Again, when I'm talking about examination scheduling, it's all going to be risk-based scheduling. So there has to be a risk indicator. Size is a risk indicator.
Sure.
It doesn't necessarily mean that the licensee doesn't properly mitigate that risk, but if you're inherently doing more volume, there's more possibility.
Right, because there can be uneducated, especially startups or whatever, that are doing it wrong. And they probably need some compliance education more than anything. What I've seen is true. Being a leader in the industry for so many years, I saw that a lot. We had people doing things as third-party debt collectors. They thought of themselves as first party.
It would, we're not opposed. So again, I'll start with size. Complaints, we need to normalize complaint data in order to determine whether or not there was a change within the agency. So if they've been producing, call it 100 complaints per year, 5 years, now it's spiked to 300. Well, there's a reason that we should go ask. And you could call that early warning system, smoke alarm, whatever term you want to use in order to put your attention there. Change in business. So if all of a sudden we see something in the news where they're significantly pivoting the structure of their business, or the entity of what they primarily have done for years, that could be a reason for us to go in and look. Again, change in management. If there's been a significant turnover at the management level, then I assume that there's probably increased risk from a compliance perspective. But these are all things that I would like be inclusive of risk indicators. That's not to say that you can't meet all of those and still be a clean agency at the end of the day.
Okay, thank you.
I think you mentioned that you also look at CFPB complaint data. If you haven't noticed already, there's been a exponential rise in those, just with a combination of what we've noticed is, TrueAccord hasn't really changed its practices, but we've seen that steep rise, a combination of social media influencers telling consumers how to get the debt collectors off their back. And one of the avenues is through the CFPB portal, and also with the CFPB's current hands-off approach. I don't think they're vetting the complaints as much. So I hope you guys are aware of that as you're looking at. There's a lot of agencies getting slammed right now and still properly responding. It's been an interesting time period.
I think one of the things I haven't mentioned is that we're going to review annual reports. So the information that we receive from our annual reports and compare that year over year, even on a 5-year trend line, to see what type of activity that's going on. Obviously, if there's a significant change one way or the other, it's going to necessitate action.
Yeah. First of all, I want to thank DFPI for providing a longer meeting. I know the last two meetings I encouraged you to expand the amount of time from an hour and a half, and you took it to 2 hours. So I don't want that to go unrecognized. So thank you very much for that. Quick question. So you said 80 hours is the average for what you would estimate to be a limited compliance audit or examination. How many hours would you estimate a full audit to be?
I wouldn't say average, I'm saying we're budgeting.
Budgeting.
Each exam could be indicative of its own risks that we're not aware of until we're there, but we're budgeting 80 hours for limited, we're budgeting 200 for full scope, and then for what I would call our multi-state or our large complex entities, we're gonna be budgeting 300. But there's only so much capacity that we have to take on
Okay.
all of those at any given point.
80 hours, if at 120, that comes to $9,600, which is still a significant amount of money for a small business that might only have 100 accounts in California that have to be licensed because they manage 100 accounts in California. So I would, encourage you to keep that in mind. Assuming that, if they only have 100 accounts, they're probably paying the $250 annual fee. But then all of a sudden, if they're charged $9,600 and those accounts, equal $12,000, they're gonna be like, why are we even licensed in this state? And you're gonna have less licensees at that juncture. And 80 hours seems like a whole lot of hours for a limited examination. I was a little surprised when you indicated 80 hours, but anyway, that just an observation.
Yeah, I'll provide some context. So assuming you have one customer account, there's 20 calls over the course of the year. Our examiners listen to those 20 calls. We're working on some, I'll call it, ability to take the recording, make it into a transcript so that we can use keyword searches to help speed up our review process. But at this point in the stage, we don't have that. So we're listening through at 1.5 to 2 times speed, trying to identify consumer risk.
Would that might be an opportunity for the FBI to use artificial intelligence to pick up the keywords so that you could dramatically decrease the use of spending time converting oral text to written text and then looking for keywords and reading an entire transcript. You might be able to reduce it by 90%. So something to potentially look at. But there are companies out there that, by the way, that our members use that look for, that pick up keywords. So I don't think even without artificial intelligence, there's already vendors out there that can provide the service at a much lower cost without having to have using such a high level manpower, if you will.
It's a question of IT resources, though. So we're exploring tech solutions, but there are costs associated with that. We have to be mindful of our budget.
Yep.
In that respect too. So yeah.
Yep.
I appreciate the thought.
You indicated that 1% of licensees did not pay their fee. Can you explain what did they turn in their license? Did they?
So there were 11 companies that missed the deadline to pay their assessment.
So the DFPI is going after them.
So the department issued enforcement actions
Okay.
for non-payment, of which I think there's 5, possibly 6 as of today that are going through the settlement process.
With the intent to remain licensed.
The intent to, I would say the majority of those with the intent to remain licensed.
Okay, thank you. I guess with the 5 minutes, my final minute, I'll just talk about going back to law firms and attorneys. See, the part of the challenge when it comes to law firms and attorneys is the fact that they are a licensed, regulated profession. They're licensed by a different branch of government. They're licensed by the judicial branch of government. They have their code of canons of ethical conduct. They obviously can be disciplined and lose their license by the judicial branch of government. And I think that's part of the concern here, that we would be licensing entities that are regulated by another branch of government, because potentially the regulations on the executive branch could conflict with the judicial branch, and then you're putting law firms and attorneys in a very awkward bind on what do they do. I get the point that you want to license law firms that only do debt collection, not litigation, but just collecting debt like a debt collector. I get that. That makes sense. But there are a significant number of law firms that operate as a law firm that collect debt, and they do have employees. They're not all licensed attorneys that have responsibilities. They litigate, but prior to the litigation, there are activities that take place, including reaching out, looking for a settlement, because the last thing that even law firms want to do is go to court. It's expensive. It may not be necessary, especially if you can get into a payment plan. I don't think we should be penalizing law firms that are litigation law firms for doing the right thing on behalf of consumers to keep costs down. And I think we should look at entrusting the judicial branch of government in California to regulate those law firms and attorneys. Now, that's entirely different than, maybe an attorney who is an attorney and might have a firm, but they don't litigate. They don't engage in that process. All they do is operate as a collection agency. And in that instance, go for it. I think you should license them.
Clarification, David, I think this goes back to the other case I was talking about where, and it's clarification for you, but maybe it continues the question and clarification. If a law firm has 3 or 4 receptionists that call people via the phone, as opposed to draft a letter on behalf of the attorney that the attorney signs, is there a distinction there? Because to me, once they start making phone calls on consumer debt, there's an education process. There's a whole, under the Rosenthal Act, but also the FDCPA, they're going to be governed. And to me, that still is acting as a collection agency. I mean, maybe I'm wrong there. I'm opening myself up for being wrong there, frankly. That's why I'm asking you as an attorney clarification.
I'd have to honestly think about that a little.
Okay.
Yeah.
Because to me, and what we dealt with the Haight and Landau case, but also when we even one of the legislators tried to pass a law about 6, 7 years ago to exclude law firms because they thought it was inadvertently omitted back in the 91, 92 era. It turned out that no, it wasn't worth their political capital doing it, because it was the Bar Association of Bars that was trying to get this exemption written because they thought it was attorney firms were exempted in error when it was actually directed directly at law firms. So, and the distinction came back to it based on the fact that they had employees making phone calls, even for settlement, that were not the attorney. Now, it's one thing that your attorney's sending a letter, even if he sends 100 letters, it's his name on the bottom of that letter using his law degree, his law license. And it's not the agency or the firm that is sending it out, because that's a form of intimidation to some degree. And we found also that a lot of those cases were not getting sued. They were trying to just negotiate debt. And, then there was a case back east, I want to say Ohio, where groups bought debt and the attorneys filed, let's say, 100 lawsuits. Any answers that were filed, they dismissed the case. I don't know if you remember that several years ago, but those are some concerns I have on the other side of that coin, that to be practical, I see a need for making sure we do it right. Right. So. Yep.
So as we were talking about this, the idea just came to my head that somewhere where we might be able to look to help differentiate the litigation law firms versus the more collection-based law firms is the FDCPA language itself. It uses the term, I think its principal purpose of which is doing one thing or the other, and that we might be able to use that as a clarification here. I'm not sure what the language would look like, but there's probably something there when trying to balance what the business does to define whether it applies or not.
I mean, my experience is most law firms represent commercial debt, commercial clients. That would certainly be outside the scope, I would think. And they're more one-on-one. It's when you sign multiple debts, you're assigning debts for collection. I think that's also part of the key. And these are just based on my experience of what has come up in the past and saying I'm right.
All of
I
that.
think we
And
have
I
public
really
comment that we
appreciate
need.
it.
Thank you. We still have 8 minutes before public comment.
Oh, we do. Oh, well, then we can keep talking.
Give you your full time.
All right, all right. I thought I had heard you at the beginning of the meeting saying that we were limited to 5 minets each,
I'm
so.
not sure everyone used their entire 5 minutes.
Yeah, by 3 minutes.
Well,
Again, I'll provide this. If there's any additional comments from any of the committee members, if not, I'm happy to move to public comment. Sure.
on the complaints. I know the FPI doesn't publish a database similar to the CFPB where you can go in and look at, you know, how many complaints were filed and what subject matter. Is it possible in the future at these meetings to have like a standardized generic report that's provided to, I guess would be made public since it's a public meeting, but provided to the committee so that we can see the nature of the complaints that are coming in, whether and how many of the complaints, because I know you do complaints far beyond just debt collection, right? So we can see what percentage of the total complaints are in there in debt collection, the complaints that are coming in debt collection, what are the nature of the complaints, things of that. Because it's hard to reflect on where there's problems or challenges within the industry if we don't have a sense of what you're seeing. I know that, and I raised this actually 2 meetings ago, whether the FPI was deploying any type of technology to identify bots. Because I know the CFPB with their portal is having a significant problem with bots. They're trying to, well, they were, I don't know if they have any staff anymore, but when they had staff, they were trying to identify how to prevent bots from going in and just blowing up the database, which I think is a real problem. I think there needs to be a way to ensure that you have an actual human being on the other side of the complaint.
Which we do.
you do.
Our consumers, our consumer services office, we have a call center, we have multiple methods that people can reach out to us to file a complaint. And we have like human beings that contact to see if there's a real person on the other end that has a real complaint.
Okay.
And so our legal team will take a look at the request about what level of complaint data we can share.
Yeah.
We do share, the main way that we've been sharing data that would be relevant here is in our CCFPL annual report. We do report aggregate number of complaints received, and by industry type. And so we do have, but that's very, very high level, just kind of the industry segment. So, you know, like debt collector, crypto, student loan company, whatever it is. So what more we can say, we'll need to just check with our legal team about what's disclosable, but we can take that back.
That makes sense.
Be more statistical, is that what you're?
Yeah, just, you know, I'm just kind of curious what, I think it could potentially be helpful to see, you know.
Appreciate it. Any last opportunity for any additional comments before to the public? Now open the meeting for public comment.
Other people raise their hand.
Good question.
I think we normally read off this instructions.
Yeah.
This is now the public comment period. During the public comment period on Zoom, to make a comment or ask a question, please use the raise hand function. You may also use the chat function to make any comment or ask questions. If you are dialing in on Zoom, you may press 2 to raise your hand to be called on for comment. You'll be prompted at the time to speak and when your allotted time is up. We will get to as many people as possible. If we are unable to get to all the questions or cannot immediately answer a question, the debt collector team will get back to people as soon as possible. So we have a few hands in the chat. I'll start with the first one as Harvey.
Announce your name and then.
Are you able to hear me?
Yes.
So my name is Harvey Moore. I'm the current president of the California Creditors Bar Association and a past president of the National Creditors Bar Association. The California Creditors Bar Association submitted comments in response to the invitation for comments. Our comments were submitted on December 11, 2025. There's been a lot of discussion today about attorneys practicing law and collecting debt. And I want to point out to the DFPI and the panel and the public that the Enabling Act provides that the DFPI does have the ability to license attorneys and law firms that participate in debt collection activity. But the Enabling Act also says that the DFPI does not have the ability to regulate an entity or individuals that are otherwise regulated by another state agency. In the state of California, that other state agency that regulates attorneys and law firms is the California State Bar. And the legislature passed Business and Professions Code sections 6000 to 6049.5, which regulates the practice of law. Within the Business and Professions Code are specific rules and regulations regarding attorneys and law firms engaging in debt collection activities. And it specifically provides that the lawyers are to supervise their staff that are engaging in debt collection activities. From the moment an account is placed with a law firm, only a law firm or a lawyer can send out correspondence on a law firm's letterhead. From the minute that account walks in the door, that firm is practicing law under Business and Professions Code section 6000 to 6049.5. So I understand that the DFPI would like to regulate the practice of law and like to regulate lawyers that are engaged in debt collection. But our reading is that based on the Enabling Act itself and Business and Professions Code 6000 to 6049.5, our activities engaged in the practice of debt collection law are already regulated by the State Bar of California. So we understand that you have the power to license us. And a lot of the law firms are paying very high assessments this year. I know our firm paid a high assessment. There are a number of other law firms that paid significant assessments to the DFPI. But as far as the ability to regulate the practice of law, which begins the moment an account is placed, I think the DFPI is a little bit misguided and is not reading the Enabling Act the way it was intended to be read when it was passed by the legislatures. And I would be happy to have a meeting with any or all of the DFPI staff to continue to discuss this issue, because this has been an ongoing discussion that we have had, and there's never been a full resolution. But I think that the law is clear. The CFPB decided not to regulate the practice of law. The ABA is very strong on their position that regulating the practice of law outside of state bars is inappropriate. So I think we need to have those discussions before the final regulations are released. And I am available at any time to do that.
Understood. Appreciate the comments. And from the enabling, you're mentioning Enabling Act. Is it the enabling statute that's in CCFPL?
Yes.
And not within DCLA?
I think it's I'm sorry, it's the enabling statute that created the DCLA.
I'll have to get back to you. Thank you for your comment, Harvey.
Thank you. I appreciate your time and what you're doing for the state and for the consumers. I think we're aligned in what we're trying to accomplish. It's just how we do it.
Thank you.
We have another question from an attendee, Rodney Meeks.
Rodney Meeks.
Is it a question in the chat or?
No, he had his hand raised. Looks like he might have dropped off.
Oh.
Let's try again.
Hello.
Hey, Rodney.
Here you are.
Hi. Thank you for allowing me to speak. I think there was a lot of conversation on small business, and I think that really needs to be taken into consideration, both from the creditor standpoint and the third-party collection standpoint. The smaller collection agencies, we represent a lot of smaller creditors. And like the comment, I don't know, it was Parisa or who it was, but they really don't have a clue what's going on, and they look for us to educate them. And they're not a large market participant from the standpoint that they might have a dozen accounts to assign per year. And I made a comment earlier. I was just approached by an electrician who he was trying to get his invoicing out, and he had his hours, but his parts he had to dig up because they had a manual process, and he didn't have the appropriate staffing to provide all the accounting for his parts. So his receivables have been sitting out there. He's been paying his employees, and he's got almost $1 million worth of outstanding receivables, and he's deeply indebted right now. So when you put him into a bucket of, hey, listen, you have to be licensed to pursue your receivables after 90 days, you're going to kill people. I mean, they will simply go out of business. And then from the auditing standpoint, I certainly hope there's a consideration for those smaller agencies with 50 and under employees, and we're under 20, and the impact of coming in and disrupting our business operations. I mean, it's all hands on deck. Everybody it feels overworked, right? They've got a job to do, and in fact, today we had to terminate an employee, and we're in the hiring process. So when you come in and you disrupt, it has a significant impact on operations, stress on employees, and our cash flow. There's unrealized cost that has a significant impact on our operations. So thank you very much.
Thank you. All right. That's the last public comment. At this point, we will start with the closing remarks. Thank you, committee members and other attendees, for participating in today's meeting. As a reminder, the 2025 annual report is due on March 16th this year. All of our examinations are going to include a review of the annual report filings. Our expectations are that our licensees must be able to substantiate the information provided to ensure compliance with the regulations upon request. The next advisory committee meeting will be scheduled later this year, and this meeting is adjourned. Thank you for your time today.
Thank you.
Thank you.
Thank you.